In this video, I'm going to walk you through and describe 6 red flags in digital cloning contracts, and I'm going to talk more specifically about voice cloning or voice replicas. It's only because those are the most common forms of digital cloning contracts we have today in the industry, and so they're an easy and a handy and common example for me to use, but you could apply most of the red flags I describe in the context of a voice cloning to other types of cloning like facial cloning or whole body cloning. Before I jump into it, let me tell you about where I come from and what I do. I am Dr. Mathilde Pavis. I'm a legal advisor and founder of Replique, which is a space I created to bring support and resources to both talent and their agents and other professional advisors on everything to do with AI, digital replicas, and associate tools and assets in between. I'm on a bit of a mission to make sure that we see digital cloning done right, and I'm not here to advocate for or against digital cloning or AI for that matter. What really is important for me is that no one enters a deal, a project, or a partnership not fully understanding the ins and outs of either the technology, the outputs, the content of what's being created and produced, and that everyone has fair and honest conversations and negotiations to make sure that you're in it for the right reasons and not because you didn't know or not because you didn't know what questions to ask. So with that in mind, this week's video is about the typical and most common red flags, and in my book, the biggest red flags in digital cloning contracts, focusing on voice cloning. Let's go through them. They are not in order of importance. They're in order in how I think it through, which doesn't mean one is bigger or more priority than the other, but they're all useful things to track when you start conversations about an AI project. Also bear in mind, I've created a checklist. It's a free resource you can download by going to our website, Replique, workwithreplique.com, so www.workwithreplique.com, and go to the resources tab and you should be able to find it, download it. I'll put it in the link below that video as well. If you open that checklist, you will see a whole range of questions to ask before investing time or money into an AI deal or an AI project to make sure you have the information you need to discern what's an appropriate deal for you or not. And some of the questions on that checklist will tap into the red flags I'm going to go through with you today. So it can be useful at the end of this video, when you're finished with this, when you've absorbed the information, to go and grab that checklist, or do it now, pause, go get it, and then come back, because I'm going to talk you through different parts of the checklist. I'm not going to necessarily refer to it in the video, but you'll see common themes and common points in both the video and the checklist. So go grab your free copy, your free resource, and then come back if you'd like. Now, the red flags, there are 6. Let me start with red flag number 1. The contract you've received, the paperwork, we're looking really at the paperwork in the digital cloning contract you have received from often the client, makes no mention of the technology, doesn't describe it or tells you where it comes from. So it would be common and best practice standards or appropriate for the contract to refer expressly to the type of technology that's going to be used and to describe the project. And when this is not mentioned, it's a bit of a red flag. It's actually a mega red flag, not a bit of a red flag, because it can sometimes suggest that we're using an old contract template that speaks to regular and non-AI creative services or non-AI like voice work. And that would not be appropriate to use a standard contract for an AI voice cloning project, because it will be missing terms. It'll just not going to be a good fit. And that's often the case when the paperwork you receive makes no mention of AI, no mention of the technology or the provider if it's a different subcontractor, and that's a red flag. So this the first thing to check is the project properly described at the top or throughout the contract? Does it make mention of AI, text-to-speech explicitly, maybe synthetic speech? Does it describe which tool or technology is being used or created or developed in the context of the project? That's red flag number 1. No mention of AI, no mention of the technology, possibly a cue that you're using an outdated template to fit what is a fairly complex and new type of work. Not good. avoid that. Number two, second red flag is that the paperwork you've received makes no mention of what we would call a privacy notice or privacy policy or a voice or data processing notice. Creating a digital clone of someone will mean processing personal data, even sensitive data, the vocal data. And for that reason, the contract needs to include a section, if not a whole document. A couple of pages are enough, but it needs to be a separate section or a separate annex to the document that clearly outlines who, how, where, and why the voice data will be collected from the talent, will be then processed, and by whom, by the client or its subcontractor, for how long that data will be kept, what are the data protection rights of the talent in the context of this project, and the legal basis for processing. All of this information should be neatly and easily recorded in the contract. Best practice is to have it separate as an annex, a couple of pages. Again, it doesn't have to be the Magna Carta, but it needs to be in plain English and clear enough and added to the contract. This document or this information needs to be in to protect the interests of both parties. So you're not being difficult as an agent if you request that information. Sometimes it doesn't come with because the person on the other side or the organization on the other side is not as prepared as it should be to do this type of work, or is not as knowledgeable yet as they should be to do this type of work safely and in compliance with data protection laws, for example. And they may need prompting by you at this stage in order to have the paperwork match the work. It's really important. It's non-standard work, so it should be coming on a non-standard contract. It's important, complex work, and the paperwork needs to fit the bill. That was red flag number two. There is no privacy policy or information about data processing in or annexed to the contract. Third red flag is the contract proposes to source voice recordings from the internet by scraping or by repurposing previous material the performer has done. That's a red flag for the scraping option. It's an amber flag for the repurposing recording section. Ideally, if your talent can and is available, that they're still alive, because of course there are circumstances when you have to repurpose previous recordings or maybe source it from the internet, and there are very limited circumstances where this is legal and lawful to do so. But on the whole, it is best practice to have bespoke recording created and produced, the talent paid for that time, a small license applied to that recording in order to fine-tune and train the model to create a voice model of them for the purpose of the project. Repurposing, scraping from the internet is a big red flag because it's a whole compliance and rights infringement risk that you don't want to be part of and you don't want to condone or encourage. So that option should be out the window. Repurposing previous recordings is a risk of a loss of income or a missed opportunity to rebook the talent in order for them to be paid those hours and for those recordings to be licensed in order to be used in a fine-tuned model. So it's best, if your objective is not saving your talent's time, but it is increasing their income potential and opportunities, it is best to ask for a bespoke recording to be made in order for them to be used on the fine-tuned model. And that is red flag number 3. Sourcing recordings to use on a model to train or fine-tune the model that is scraped from online, big no-no, or that is repurposed from a previous catalog or portfolio of work. It's an amber flag. It's not a red flag, but it's still not the best if your objective is to increase income or earning potential for your talent. Fourth, the contract does not clearly list the different assets that will be both needed and created in the digital cloning or voice cloning process. Those key assets are, number 1, you will need voice recordings, as I've just mentioned, in order to fine-tune the model. And then you will create a fine-tuned model that is a separate persistent digital asset in which lives your talent's personal data and intellectual property. And third, you will have the output content of created by this fine-tuned model that will be generated on demand in the voice of your talent without them being involved at that stage. Those 3 key assets are very different. They need to be listed and spelled out clearly in the contract. And against each of those assets, you should have a separate rights transfer or licensing agreement, because they are very different, they behave differently, and you cannot wrap the same buyout or the same licensing right agreement on all three. You can't lump them together. It is no bueno for your talent. It is too risky. It does not fit the bill. It does not reflect the fact that the fine-tuned model is an asset that is high risk for your talent, because it is their digital replacement potential right there and then. And who owns it, who accesses it, for how long they have it, etc., needs to be different from the sound recordings that were used, that actually are used at the beginning of the process, and then after that they can be deleted and they're never going to be used again, really. And they're different from the outputs, which will be the content that will go out to the public most of the time in order to be embedded into an advertising campaign, into a video game, into I don't know what it could be, corporate education, website videos, etc., etc. And so there are two different assets. The outputs, you know very well how to manage, because they are the same, or should be treated as the same as as licensing an output or a recording of someone showing up in a studio in a regular way. So the outputs, you know, it's your bread and butter, it's your typical agent business, you know how to deal with it. The fine-tuned model is this new, sensitive, risky asset that shows up in the digital cloning process, that needs to be treated differently in your contract and be given a bit of space and room in the negotiations, in the sense that you need information about who creates this asset, who will access it, for how long will it sit, and on whose server, and when can I delete it, all of these questions. If this is a lot of content, it's normal. It should feel like a lot of content, especially if you're new to this, but do not worry, because we cover it in our videos through many different angles, so you will get the hang of it. Also, if you go grab that free checklist that I talked about earlier in the video, it will outline all of these different points and questions in a way that you don't need to absorb and understand and process it all right now. Okay, so this was our fourth red flag, is the problem of having not seeing those three assets, the sound recordings, the fine-tuned models, and the outputs, as listed separately in the deal. Now, fifth red flag is there is no moderation, or there's no information or no obligation about moderating the outputs that will come out of the fine-tuned model. So this is a problem, especially if the fine-tuned model, the voice model of your talent, will be made available to a larger group of people with little to no gatekeeping. For example, if it's available on the website for anyone who visits the website to input text and listens to or download a piece of audio that they will have inputted, and there is no moderation on that page or in this setup, it's really high risk for your talent, because their voice can be heard to be saying all sorts of inappropriate content, whether it's explicit, whether it's politically divisive, whether it's hate speech or inappropriate speech, you name it. That can also be a problem if your talent has prior exclusivity obligations towards certain brands or companies or clients that they need to maintain. So you do need to have moderation in at least those two scenarios. It can also be really important if the voice model is embedded in an in-game experience that is accessed or used by lots, maybe hundreds, thousands, or millions of users, of gamers or consumers, or organization with a large number of employees that will be able to prompt content on demand and to their heart's content. Because you don't know, and you won't be there to know what is being said necessarily, you need to have moderation mechanisms and commitments, contractual commitments from the company to you through the clients. And you need to check whether the contract covers this topic, and if not, ask about it and ask for protection. You could have human moderation with it, which is human reviewing the content before it is made live or can take it down quickly, or you could have automated moderation, which is when we have filtering or blocking of content based on key prompts Both options are good. Human moderation can be better because more nuanced and tailored, usually slower and more expensive. So usually a combination of the two is your best option. That is an expense on the side of the client. It is not needed for all contracts, because often if the voice model is only going to be used by one client and it's a small pool of employees and it's a small group of people that have access to the model and that will be in charge of prompting content with the model, then you don't run high risks of misuse. But because the cloning contract could have all sorts of shapes and be used in all sorts of contexts, it's important that you check that point based on the facts and the particular scenario you're looking at. So for me, it's a red flag if, when needed, there is no moderation mechanism in place and no firm contractual obligations to that effect. Should something go wrong, you want to be able to claim indemnity or compensation from a company that may have misused or not kept safe your voice model. And last but not least, the fine-tuned model, the voice model that encodes your talent's voice in a computer software that is now being handed over or given access to by a client, if that fine-tuned model is basically transferred or owned or controlled or managed in perpetuity by the client or by a third party other than your own talent, other than the talent and the agent, that's a red flag, because that's essentially handing over the key and the rights and the control of your talent's digital voice, and you might say their digital self, to a third party provider or to a third party client or organization. And for the period of a lifetime, it can be really invasive, intrusive and disruptive of both their personal life or their career to hand over such control without, if there's no terms to renegotiate or to withdraw consent, if you don't have the opportunity to terminate, withdraw consent, request deletion and cease and desist in using the fine-tuned model, I think a perpetuity transfer of access, control or management of a voice model from the talent to another company is a huge red flag that I would warn you against every day, all day. And I understand that sometimes that is leveraged for a high sum of money, and that sum of money can be quarter changing, then forget about it, year changing, I understand it makes you stop, but unless that sum of money is life changing, I wouldn't even contemplate the idea. A safer deal is a deal that runs for 2, 3, maybe max 5 years with a particular brand or particular production, with a really narrow and specific use of voice cloning, say for a character, for a campaign, or that is firmly time limited. If it goes beyond 5 years, you need to have an opportunity to renegotiate and reconsent, or to withdraw consent and request the deletion of the model, and ask what the consequences, commercial terms of that would be. But don't shy away from that question, because most of the digital cloning examples that have gone wrong, that have hit the headline in the media, have been instances where all deals made 10 years ago are still hanging over artists and actors' career today, to bitter regret, and to know there is no money that makes it okay. And most of the time they're not well remunerated, but even where they were remunerated to a decent level, that's not enough for the disruption and loss of autonomy that someone experiences in that scenario. So there you have it, 6 red flags to track and try to move to a green flag, or then to walk away from the project if you can't do anything about them. And those are below your standards as an agent, as a talent, or as a business more generally. I'll see you in the next episode. And if that's helpful, if you have questions, get in touch. We love receiving notes and comments and feedback from the content we put out.